that however this is done, there will need to be a guarantee fund in place for other providers.
I think our view is that we would like to have, reciprocal arrangements for consumers. So for them, it doesn't become an important choice which provider they go to. They know that they are sufficiently covered whether they go to an ABS or to traditional firm practice.
Yes or no?
Well, I think it would be relating to legal services providers.
Okay. Because, in other areas like ABTA and travel agents and all that, we're trying to get increased protection against, people running off with the funds, going bust, whatever, aren't we? Ought that not to be a principal objective of the regime we set in place here? That there should be that level of protection to the consumer?
I think we certainly want an equal level of protection to the consumer that people have with the traditional arrangement, if you like, yes.
Now, in terms of will providers, there's a proposal, I think, that the Scottish Government are looking perhaps at stage 2 amendments on the question of regulation of will providers. I wonder if I could ask which in particular on this one, whether you support that particular proposal.
Well, we think there is some opportunity for people other than lawyers to write wills, frankly, and we would like to see that examined. We have no evidence that there would be any difficulty with that, provided it's properly done at the time. But we think there is opportunity for competition in that area which would benefit consumers.
Do you mind if I explore that a bit further? Can you tell me something about the relationship between which and which legal services? Yes, as part of our organisation, we have Which Legal Services, which offers legal services to the public for set fee. So because I'm looking at the evidence that's been given to us by the Scottish Law Agent Society, who tell us about this particular service. I must confess I knew little about it before, which indicates that these are what are called execution-only legal services, where the provisions provide that the service doesn't provide legal advice. It uses software for the assembly and drafting of a will based on the answers given in the will. Your will will therefore be generated automatically to reflect the answers you've given. You are responsible for ensuring the answers and information are accurate, and the terms and conditions, I think, make it clear that it operates under English law. Now, that doesn't sound like a legal service. That sounds like a technical IT service with little regard to the intricate complications of will drafting. Could you make any comment about that?
I suppose it's part of the opportunity that people have to access different legal services, really, which is partly what we're looking to happen, really. We're hoping that in Scotland there will be a different provision of services so people can pick the one that's appropriate. For some people, obviously, with a hugely complex estate, then you would, I'm sure, want to go to a solicitor and have it done in that way. For someone with very simple affairs to settle, perhaps, that would be the way that you would choose. It really depends on who you are and what your circumstances are. But certainly I think that provision of a plethora of services is very important.
Most lawyers, I think, would indicate that the question of wills and the interpretation of wills and the effects of intestate law are amongst the most complex areas and the most difficult in terms of the challenges and disputes they lead to. Would you accept that?
I accept that in some cases that's the case, but I think in other cases people have fairly straightforward affairs, and it really depends on who you are, and I think finding the appropriate level of support and services is very sensible.
It leads on to a more complex question, which is the place of professional knowledge. Solicitors are, there's competition amongst solicitors, amongst advocates, obviously. They are trained by quite a lengthy process. You wouldn't expect a brain surgeon, perhaps, to have his business opened up to competition, I don't imagine, would you?
Well, I suppose I wouldn't expect a brain surgeon to, take out someone's tonsils, perhaps. It's the right professional for the right professional piece of work, I think, that's important, and the right safeguards.
That's my point, really. Where does the professional standard and professional training come into all of this?
Well, which has, properly trained lawyers to hand, obviously, on staff. So I think that's where it sits, that's where it rests.
In terms of alternative providers, would that be a necessary requirement, do you think, in terms of what the bill is suggesting, that alternative providers would have to have fully qualified lawyers if they're doing anything in the legal sphere at all?
I mean, I think in Scotland we have, for instance, independent conveyancers, which is an area that we'd like to see more competition in. It's an area that people use in terms of legal services quite frequently. And I think added competition in that area, for instance, could drive down prices and benefit the consumer. At the moment, they are regulated by the Law Society, which we feel is not appropriate.
My point really is that where does professional competence come into this? What are the standards of competence that would be required by people operating in these sorts of fields? Because I don't think licensed conveyancers, for example, are solicitors or trained as such, are they per se?
They have legal training, and I'm sorry, I can't tell you exactly what their standard of.
Can I just help?
Help us here.
With the licensed conveyancers, they obviously undergo training to get the qualification. So it's obviously more focused on the sort of role that they have. So it's not the full, as detailed or as lengthy, I don't believe, as the solicitor training. Similarly with, I imagine, will writers, they will, in England and Wales, there are a number of bodies that have members of will writers where they will have to undergo training and also continual professional development.
I suppose what I'm getting at is the division between different sorts of areas of the law. I mean, there are clear things appearing in court and all that, subject to Mackenzie Friends and things of that sort, where there's a preponderance of the legal training, if you like, would be important. There's maybe other areas where less so. There are issues of welfare law where people like Citizens Advice Bureau and others come into the field and give very good advice in that kind of area. Is there any view from the Office of Fair Trading about the core legal services, if you like, where a professional, qualified legal training is required?
Any professional training or skill has to be appropriate to the service being offered.
So can you translate that into areas where that has to be the case, and areas where it's maybe more an overlap with other professionals?
I think that's a bit more difficult to do. I mean, obviously, if you are dealing with very complex cases, then your sort of necessary training and perhaps the level of qualification must be higher than if you're doing sort of very sort of procedure, regular sort of everyday that you're doing all the time, that there isn't such a steep learning curve, or the skills required are different. So to give our surgeon analogy, for example, I'd imagine that you'd need far more skill to be a brain surgeon than perhaps if you are, perhaps someone who helps out in an ambulance and offers some sort of, accident emergency help.
Where does the expertise come in feeding into the regulatory body? If it's not the Law Society or ICAS or a professional body of that kind, where does the expertise come from that enables them to set standards for other groups or people as to the level of training and so forth?
Well, I mean, obviously, there have been organisations like the Faculty and the Law Society that have been around for, many generations, if not centuries. So that has evolved over time. Say with some of the newer bodies, they may well have been approved under statutory provisions where they have to provide a suitable scheme of arrangements to the Lord Chancellor or to Scottish ministers, who then ask for input from the Lord President and the OFT. So the rules start off in that way, and then they're developed over time, monitored and reviewed, as are the rules of the Law Society and the Faculty.
Thank you very much.
Good, that's as far as we're going to get. And a final brief point from Cathy Craigie.
Just brief point to the two organisations represented on the panel. Would the OFT be making such strong representation in support of this bill if it wasn't for the super complaint that which had lodged, and which is a charitable organisation representing consumers? I think the members round about the table have shown to you that we recognise as consumers as members of the public and not necessarily large business. Before the super complaint was submitted, what sort of consultation did you do with the public? And what would you say to this perception that's out there that this bill is for big business and will drive down the business in the high street? And the point that it's an open door for third parties to come in and profit rather than consumers receiving justice.